One of the biggest changes I've seen in child support practice over the years concerns paternity testing. When I first became a lawyer in the 1980s, they were horrible, unseemly cases. A man who thought he wasn't the father of a child often had to arrange to bring half the local football team into court to try and convince a magistrate that the mother had been particularly promiscuous at the time the child was conceived. Fortunately, all that is behind us now. With DNA testing, we can establish to a very high degree of probability whether a man is the father of a child. But the issue remains though. The man who was shown not to be the father of a child, can he be compensated? Clients will often say to me, I've been on an emotional roller coaster here. I've raised a child who isn't mine. It's been expensive. After the separation, in fact, I've had to pay child support. Ought I not receive some sort of compensation for having been taken through that process? Now, the issue went to the High Court in 2006 in a case called McGill. It's reported in the Commonwealth Law Reports for that year, and those who have access to a law library will see it reported at page 550 of volume 226 of the Commonwealth Law Reports. In that case, the father sued the mother for pain and suffering, and he sought $70,000 in compensation from the mother. He used an old cause of action in the law based on a case called Derry and Peake. Derry and Peake was decided in 1889. It's reported in volume 14 of the appeal cases for that year, and interested readers will find it reported at page 337. In McGill, the High Court said the law of deceit doesn't apply in child support cases. And in particular, it said it didn't apply in child support cases in the McGill context because the mother never actually represented to the father that he was the father. The father, not unreasonably in my view, just assumed that he was the father. He was married to the woman at the time, but the mother never actually represented to him that he was the father, and that's why he failed in the case of McGill. The High Court said that he wasn't entitled to compensation. But fortunately, there's a statutory way of proceeding as well. And for that, I take you back to our old friend, the Child Support Assessment Act of 1989. Paragraph or section 143 of that act says, prima facie, if a man is shown as a result of DNA testing to not be the father of a child, he can make a claim to the court to be reimbursed the child support that he's paid. And as a general principle, you would expect that if the mother has the financial wherewithal to pay, that the child support the man has been assessed to pay and has paid ought be refunded to him. The court's got a great deal of discretion in these cases, but ordinarily you would expect the man to be awarded at least the child support that he has paid. He's not entitled under section 143 to compensation for pain and suffering, all the trauma associated with raising a child that's not his, but he ought to be able to get the child support back. I'm Simon Bacon. I was a child support lawyer for 35 years. And if you have any questions regarding the issue of paternity testing, have a look at my website, childsupportlawyers.com.au.